Do you want me to go, Your Honor, or do you want me to?
Do we need a break for 5-10 minutes, or do you want to go ahead? Like everybody's ready to go ahead? Why don't you go ahead?
Ladies and gentlemen, believe it or not, my favorite jury instruction is the burden of proof, because it says exactly what your job is. Your job is not to search for doubt. Your job is to search for the truth. What you just heard was the smoke show continue that Josie started, the defendant started with her testimony. Look at all of these other things, but how much of what the defense argued focused on the 2 days involving Alex Xavier's death? Heck, how many times did you hear the name Alex or Alex Xavier during their comments? They brought up the 2011 and 2013 other acts as if that was the entirety of what the state relied on. The state's argument regarding those was less than 5 minutes, and the state's argument regarding those told you exactly what the law says on how to use it. They're the ones that brought up using it improperly. I want to talk first about the accusation about the investigation in this case, and that there was tunnel vision associated with this defendant, because nothing could be further from the truth. The defense gave the example of a puzzle that is missing pieces. There was a puzzle with missing pieces in this case, but it was the defendant that was taking those pieces away from the. When they responded that day, they were first responders trying to save Alex's life. They performed CPR on Alex's body. In the efforts of trying to perform CPR on Alex's body, they moved the pill container. They put it on the bed. They touched it. When this case was first being investigated, as an overdose. That pill container was sent out to the crime lab to see if it had Alex Xavier's DNA on it. Why? Because law enforcement was looking to see if this was, in fact, an overdose, just like the defendant said. That's why they sent it out looking for Alex Xavier's DNA. They were investigating it as an overdose. If you looked at the first search warrants in this case, which was brought up, the first search warrants were looking at child neglect resulting in death because they were looking at it as a potential overdose where drug exposure happened in the home. Is that pointing the finger at this defendant? No, that's keeping an open mind. You heard that the defendant willingly gave over her cell phone. You saw the video. Investigator Williams said, we're going to get a search warrant for your phone. She knew they were going to get a warrant for her phone. It was with that information that she turned it over. But the defense paints it like it was a voluntary, here's my phone, here's my passcode, look at whatever you want. That's not what she did. And don't let them portray it that way to you. Law enforcement did investigator search warrants for her accounts, Google, Facebook. But they also did them for Mr. Pedrin. They were also examining him as a potential suspect. You heard that they did search warrants for her and for Mr. Pedrin. But it was this defendant's words to investigators originally, and this is important. That morning, she said that Alex Xavier was asleep the entire time that Mr. Pedrin was home. Alex Xavier was asleep the entire time that Mr. Pedrin was home. Why is that important at that stage of the investigation? Because the autopsy is done on February 13th, and that's where they see all the internal injuries. Based on the internal injuries, they now know that this is a child abuse case, that it's a severe child abuse case. But what the defense doesn't want you to know is that the investigators are relying on her word during this portion of the investigation. Her word is that Alex Xavier was asleep during that time frame when Mr. Pedrin was home. And so what does that mean? That narrows the suspects. Mr. Pedrin couldn't have committed the child abuse according to her words. And so they have now lost probable cause to get a search warrant for his phone. But they don't tell you that. And so they continue to investigate. They have the internal injuries. They have the forensic interviews of the children. and the forensic interviews of the children, in all of the forensic interviews, not one of the children ever says that Mr. Pedrin does any form of child abuse to any of them. Orion, no child abuse by Derek Pedrin. Brantley, no child abuse by Derek Pedrin. Major, no child abuse by Derek Pedrin. But they all point the finger at this defendant alone. Those children were in 2 separate homes, and they talk about hitting, kicking, and choking by this defendant. That's magnificent coaching by some power from above that children in different homes can magically say the same thing unless that's what happened. And so now, they are looking at this defendant for child abuse. Because this defendant's own children say she's a child abuser. And then they get the toxicology results. And they have a conversation with Mr. Pedrin. And I want you to think about what Mr. Pedrin says regarding the toxicology results. I buy Xanax. He's admitting that he illegally purchases Xanax. He's admitting that he illegally purchases Xanax for her. And who has the phone? The only phone with a text message that comes back to Xanax. This defendant. Text message to her mother saying, do you want to try a Xanax? What does that message tell you? She has Xanax, she possesses Xanax, and she's willing to give it out to someone else if they want to try it. Now, she's had the benefit of listening to everyone testify. She's had the benefit of seeing that text message and knowing it's going to come into evidence and having to come up with an excuse for it. And how much did you hear that she was prepared? She initially said that she prepped every week since being charged in this case for the moment that she was on the stand. Think about when she was charged with the offense and she got a copy of the criminal complaint. And it mentions the child abuse, and it mentions the Xanax for the first time. She knows about the results. Who's the first person she calls in this world? Mr. Pedrin. What does she say to him? I love you. Repeatedly. I love you. Do you love me? I want to talk to the children. And what does Mr. Pedrin say? He allows her to talk to the children. You heard arguments from the defense about the theory of the case. The theory of the case. Investigative Sergeant Rich Amundsen testified that Mr. Pedrin is still a suspect. What do you know about this case? You know he was bringing Xanax into the home. Heck yeah, he's still a suspect. You know he committed child neglect. Heck yeah, he's still a suspect. There's nothing that Investigative Sergeant Amundsen said that is not true. But they want you to believe that because he's a suspect in those things, he's a suspect in the abuse and death. That's not what was said. They were asked if he was still a suspect, and the answer is yes. To neglect, to delivering Xanax to her. And you're asked about a working theory of the case. You heard the theory of the case, not from Investigator Williams, who was removed from the case after doing a few months' work on it, is obviously upset about being removed from the case, and hasn't done any work on it since, but you did hear a complete theory of the case from the investigator that's been on it ever since. Let's talk a little bit about the DNA evidence, because the defense wants to make a big deal about that DNA evidence, right? You didn't test the bag that belongs to this defendant. You didn't test the pill container that belongs to this defendant. It was tested. It was tested for Alex Xavier's DNA. And then when they went back and watched the body cam, they saw CPR being performed. And then they saw those containers being moved. That's Alex Xavier's DNA being transferred to those containers. The bag is her bag. Of course it's going to have her DNA on it. What they didn't explain and what they can explain, because it demonstrates her guilt beyond a reasonable doubt, is that bag coming down and being put on the floor, is that pill container being emptied out, is that pill container being used to stage an overdose. And what did that buy this defendant? It bought her time. It bought her time that day because the investigators allegedly looked at the scene and said, this does look like an overdose. But then they started putting the pieces together. They started looking at the evidence because what they didn't know when they responded to that scene was all the internal injuries that Alex Avery had before he was administered those drugs. When you know those injuries and you know how severely this child was abused, when you know that in the context of this bag and a child having to open that container, and when you know that the pills were dumped in that bag, you know it's staged. The defense also keeps throwing out overdose, 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 as if that's what the medical examiners said in this case. The practice of medicine involves differential diagnosis. It involves looking at the entirety of the facts in the picture. If you look at just the pills and the toxicology results in this case, it's consistent with overdose. That was the question. But you have to look at it in the context of a beaten and battered child who is then drugged, who is then given the amount that could kill an adult human being. Who is given an amount that's going to result in that child being unconscious and dying within hours. That completely removes Mr. Pedrin. There's only one person in the world who had the ability to administer drugs to that child, this defendant. There's only one person who had the ability to abuse that child without anyone else knowing about it. That's this defendant. There were other children in the home. Mr. Pedrin was there. She said Mr. Pedrin couldn't have done it originally. It was only after being charged at trial that she says, this is what I heard in the bathroom. But you also know that didn't happen because you know how severe those injuries are and you know how symptomatic Alex Xavier would have been. A fractured rib, a lacerated liver, bleeding into his mesentery. You saw the photographs of all of his injuries. You heard that law enforcement had contact with him and saw none of that. You heard that Laura Lee heard a voice of a child that was okay at 10:30 at night. Dr. Quinton testified that both the injuries and the toxicology in his system were substantial factors to his death. So no, it's not correct that if you rule out toxicology as an overdose, and if you look at just the pill matters, that this isn't a homicide. That is not what Dr. Quinton said. And the other forensic pathologist, the one who didn't write a report, if we're going to criticize law enforcement for not writing a report during a meeting with somebody, what about their forensic pathologist who didn't write a report with all of his findings and conclusions? It was left to me asking questions, only to find out that his opinion is that an adult abused a child, that he would have been symptomatic rather quickly as a result of those injuries, and that with that amount of toxicology of Xanax in his system, he would have been unconscious and dying within a few hours. That was their expert's testimony, that he couldn't bother to put in paper despite being paid $12,000. Why, the defense screams. The instructions that you have in front of you say that the state does not have to explain motive. And don't let them put that on the state. That is not the state's responsibility. The state's responsibility is to prove facts and evidence. And the facts and the evidence are that this defendant brutally beat a child and then administered Xanax. There's only one person in the world that could stage that scene, to bring that bag down, to empty the pill container, to put it by the body, to buy more time. Those who have nothing to fear have nothing to hide. Who's the person who's been hiding things and concealing things since the very beginning of this case? Whose testimony wasn't even commented on by the defense? This defendant. If children get something wrong on the stand, they're inconsistent. If children are too consistent, they can't be believed. That's also what was argued in this case. What kind of world do we live in where we can attack a child no matter what they say in a courtroom? It's just never going to be good enough. Because child abuse is a crime that happens behind closed doors, and if it's children that witness it, too bad, so sad. No matter what, they just can't be believed, even when they're that consistent. Those who have nothing to fear have nothing to hide. This defendant has hid a lot. Tell her that you see her. Tell her that you see her for who she is. Tell her that you know what she did to Alex Xavier. Tell her she's guilty.
Thank you, Mr. Torbensen. So, ladies and gentlemen, carefully consider the closing arguments of the attorneys, but arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence and upon the instructions given to you by this court. You are to decide this case fairly and impartially, without fear or favor and without passion or prejudice. You are to decide only whether Josie Dikeman is guilty or not guilty of the offenses charged. Any consequence of the verdict are matters for the court alone to decide, and you must not must not affect your deliberations. Now, the following 8 forms of verdict will be submitted to you concerning the charges against Josie Dikeman. In count one reading is, we, the jury, find Josie Dikeman guilty of first-degree intentional homicide as charged in count 1 of the information. Another, the second reading, we, the jury, find Josie Dikeman guilty of first-degree reckless homicide as charged in count 1 of the information. The third reading, we, the jury, find Josie Dikeman guilty of second-degree reckless homicide as charged in count 1 of the information. The fourth reading, we, the jury, find Josie Dikeman not guilty of count 1 of the information. Another reading, or count 2, another reading, we, the jury, find Josie Dikeman guilty of chronic neglect of a child. Consequence is death as charged in count 2 of the information. Another reading is we, the jury, find that Josie Dikeman not guilty of chronic neglect of a child. Consequence is death as charged in count 2 of the information. Count 3, one reading, we, the jury, find Josie Dikeman guilty of physical abuse of a child, repeated acts causing death as charged in count 3 of the information. If you find Josie Dikeman guilty, you must answer the following questions. Did at least one violation cause the death of the child? Yes or no? To answer yes, You must all agree on the violation that caused death. If you answer no, you should consider the following question. Did at least one violation result in great bodily harm to Alexavier Pedrin? Yes or no? To answer yes, you all must agree on the violation that caused great bodily harm. The final reading, that's on the second page. We, the jury, find Josie Dikeman not guilty of physical abuse of a child, repeated acts causing death as charged in count 3 of the information. I just point that out because it's on a separate page in the verdict you'll be given. It is for you to determine whether Josie Dikeman is guilty or not guilty of each of the offenses charged. You must make a finding as to each count of the information. Each count charges a separate crime. You must consider each one separately. Your verdict for the crime charge is one count must not affect your verdict on any other count. This is a criminal, not a civil case. Therefore, before the jury may return a verdict which may legally be received, the verdict must reach unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a verdict. When you retire to the jury room, select one of your members to preside over your deliberations. The presiding juror's vote is entitled to no greater weight than the vote of any other juror. If you need to communicate with the court while you're deliberating, send a note through the bailiff signed by the presiding juror. To have a complete record of this trial, it's important that you communicate with the court only by written note. If you have questions, the court will talk to the attorneys before answering, so it may take some time. You should continue your deliberations while you wait for an answer. The court will answer any questions in writing or orally here in open court. When you've agreed upon your verdict, have it signed, dated by the person you have selected to preside. After you have reached a verdict, your presiding juror will notify the bailiff that your verdict has been reached. Everyone will return to the courtroom. The verdict will be read into the record in open court. The court may ask each of you if you agree with the verdict. So at this point in time, we're going to swear the officers. No, we'll do the alternates after we swear the court officers.
Do you swear that you will, to the best of your ability, keep all jurors sworn on this trial together in some private and convenient place until they have reached their verdict or are discharged by the court, and that you will not, before they have rendered their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon?
All right, at this time, we'll select the alternates. The two numbers, because today is May 14th, 5 and 14. By the way, your names are randomly given different numbers, 1 to 14, so I don't even know what that is. There's two random numbers here. Who are the two alternates? And rather than their names, if we could use initials.
You want 5 and 14?
5 and 14. Initials.
NK.
Is there only one NK here? NK? Nobody's NK? Okay. Okay. WM. Okay. So we have the two. So the two alternates, what I'm going to do is have all of you go on out. The two alternates, if you could meet me in my office, we have a couple minutes to do some things, but I want to talk to you for a minute. Oh, thank you. Please leave your instructions there. I will gather them, we'll bring some back, and we'll also bring you the verdicts. Thank you. Everybody may be seated. Some minor detail that just occurred to me is tomorrow we have a different bailiff coming for one of the bailiffs, so we'll have to swear that bailiff in. My question is, we should do that on the record when they get here. Parties can be there, obviously, for the swearing. I would do that at 8:30 tomorrow. Well, as soon as they came up with the jury. That's just we just have we have a different bailiff tomorrow afternoon. So somebody can come up to represent the parties. Not everybody has to be here necessarily, but just so you know. I'll ask them to show up at 8:30, and as soon as they're all here, we'll ask them to hold off, and then once the jurors or the bailiff is sworn, we can start. Does that sound like a way to deal with that, Mr. Torbensen? That just occurred to me that that's an issue tomorrow.
Yeah, we can make that work.
Judge.
Okay. Then the other, first of all, was there any problem with how I did the final reading of the jury instructions, Mr. Torbensen?
No.
Mr. Zacher?
Oh,
yeah. My usual practice is not to send any exhibits back. If they ask about an exhibit, I'd probably end up calling you and asking what you feel about it going back. Give us numbers so we can reach you. I initially start with a call. If we need more of a hearing, we'll bring everybody in. The other thing is we're telling the jurors that they can go to about 5:30 tonight. We will break and have them come back tomorrow morning, as I think I said. I'm not sure I said this, but that's what our intention is, 5:30 to 6, whenever they want to break.
Judge, is your intention that if we get close to 5:30 to come on the record and dismiss them, or are you going to dismiss them without coming back?
I will put it on the record.
Okay.
And so we do need somebody available.
Okay.
Between 5:30 and 6 if they feel like they need that break. If we find out otherwise, we'll let you know. But anything further from the state?
No.
Anything further, Mr. Zacher?
Judge, I do have to put objections to the state's rebuttal on the record here. Once more, the concern is burden shifting when the explicit language is what the defendant didn't explain, and expecting a response or an explanation from Ms. Dikeman's side of the case. Additionally, we're going to object to mischaracterizing when the state indicated that all 3 children said that Ms. Dikeman abused Alex Xavier. It's arguable even with 2 of them, but Araya in particular said nothing of the sort.
Okay. I may change my practice and do so 160 after, because I think that addresses that issue somewhat, which is when you do 160, you say, rely on the evidence. Now, just so you know, I'm not making any comment about it, but what I'm trying to say is that if there is, because rebuttal happens, you can't respond. If there is evidence which is not in the record, that tells the jury, hey, you're supposed to disregard it if it's not there. So I think you have to put the objections on the record, that's clear. But I'll note those objections. I'm not going to do anything at this point with the jury and deliberations. So.
Thank you, Judge.
Just for the record, the forensic video of Araya talked about soap in the mouth, and I would consider that a form of potential abuse, especially from a non-parent doing it. But so she did make that statement during her forensic.
Okay. All right, give us numbers. Like I said, we'll let them deliberate for a while, and hopefully we'll let you know if something happens. Thank you.
Prank calls are fine.
Hey, do you want to write yours?
Dreams. Yeah. I'm always up in the middle of the night, so.
All right, thank you, everyone. Oh, shoot, let me give this to them.
Are these just our copy?
Yeah. Yeah.
Do we stay here?
Stay relatively close and keep calling. I will need you back at 5:30. Yeah, I do. I can't get out of the enclosure here.
not all gonna fit.